3, 2, 1. Okay, hello, welcome, bienvenidos. Hello, welcome. Thank you all so much for being here. Let me start on Instagram also. Welcome, everybody, and welcome to another episode of Deportation Defense Live. My name is Otis Landerholm. I am the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And I want to thank each of you and welcome you to another episode of Deportation Defense Live. It is the 25th of October of 2022, and I'm excited to be here. Thank you for being here. And so, our theme for today is how do I apply for VAWA if I'm in immigration court? Okay? And so welcome everybody, and thank you for being here. So here at the Deportation Defense Live, we're here to train, teach, inspire, and empower immigrants who are facing deportation to make the most out of immigration laws, to make the most out of their lives, and to win their cases. Are you facing removal in immigration court, or do you know someone who's facing removal in immigration court? Because if so, you know that it is not easy, all right? It is an uphill battle. The laws are against us. And here at the Deportation Defense Live, we're here to maximize your chances of winning that case. So today our theme is how do I apply for VAWA if I'm in immigration court? And as always, we'll do this in English and then we'll do this in Spanish. And if you have questions as we go, please feel free to send them over. All right, I don't have questions submitted in advance today, so if anybody out there has questions, send them on over. I'll address them live. And if not, no worries. I will make it, short and sweet, and we'll get into our Spanish version. All right. So Carmen, I see you there. Hello. Thank you. All right. Awesome. So as always, I like to start with an empowerment tip. All right. So I'm going to do that. So my empowerment tip today is to encourage people to exercise the muscle of being decisive. All right. What do I mean by that? If you have a decision to make in your life and you've been putting it off, make the decision. I don't know what that is in your life, but it's like if you're on the fence about something, stop being on the fence. Get off that fence, make a decision one way or another, and go for it. Many people, myself included sometimes, delay and delay and delay, especially when there is a tough decision to make. All right? Oh, I'll just wait for the right time. Oh, I just need more information. Oh, I'm just not ready to decide yet. And then before you know it, the year passes you by, life passes you by. And the change you want doesn't happen, and the opportunities you want don't materialize, and you don't reach what it is you want. So my tip today is to start being more decisive. Like, go for it. You can do it. And being decisive will help you to achieve the life you want, all right, including in your immigration process. Like, am I going to file for a green card or aren't I? Is now the right time or not, right? Decide, all right? And the first step in that decision is get good advice. There's no problem, no harm with getting good advice. In fact, that's the right way to do it, okay? And immigration case aside, right, if you're like, thinking of buying a home or opening a business or something like that, getting into a relationship, right? Whatever it is, if you make the decision and it ends up being the wrong decision, a lot of people are afraid of this. If you end up making the wrong decision, hey, you know what? Great. Because at least you made a decision. And hopefully at least you learned something from it. And that knowledge now can guide you on your way so that you can make a better decision next time. So anyway, my tip today, exercise the muscle of being decisive. Don't be afraid to make decisions. They are the way to achieve what you want in your life. All right. Thanks for listening to me. All right, hope that was useful. So now I want to get into the legal aspect of this theme, which is how do I apply for VAWA if I'm in immigration court? And as always, I like to start with the basics. All right, might as well start with the basics. So let's see. I want to make sure I'm live on Instagram. It's like the connection failed or something. Okay, now I'm live on Instagram. Everybody on Instagram, sorry about that. I hit the button and then there was a snafu there. So anyway, now we're live on Instagram. Welcome to everybody on Instagram. If you're joining us on YouTube, TikTok, Facebook, hello to you as well. Welcome to another episode of the Deportation Defense Live. My name's Otis Landerholm. Landerholm Immigration, A.P.C, where we fight for your American dream. Today we're talking about how to apply for VAWA in immigration court. All right? So VAWA is the Violence Against Women Act. And VAWA allows people, men, women, doesn't matter, it allows people to apply for a green card if they've been the victim of either extreme cruelty or abuse, physical harm, or other types of cruelty. All right? It doesn't have to be physical harm. In their marriage to a United States citizen or a green card holder. Okay? But if a person is in immigration court, it makes that process a bit tricky. All right? It makes the process tricky. Basically, there's three ways to do it. And I want to go over them here today. You ready for it? All right? You ready for it? Okay, three ways to apply for VAWA if you're in immigration court. The first way, all right, the first way is to get out of immigration court first. All right, and we do that through what's called a motion to terminate. Do a motion to terminate first, and then do VAWA one-step AOS altogether. One-step AOS means you're filing the VAWA I-130 self-petition and the green card application all together before USCIS. Now, this first way of doing it will only work if your spouse is a U.S. citizen. All right? If they were a green card holder, you can still do VAWA, but you can't do it as a one-step. You got to wait for the priority date to become current. All right? Which you could check the visa bulletin. Sometimes it actually is. Anyway, talk to a lawyer if you have confusion about that issue. And you can only do this first way, this first method, if the judge, or sometimes DHS also, is willing to allow you to terminate your process to do this kind of case and to file in front of USCIS. This can save a lot of headache, a lot of stress, you don't have to do nearly as many hearings. It often is much less expensive to do it this way. And essentially what you're doing is, hey, let's close this case in immigration court. Let's file for VAWA in front of USCIS. And that can happen. You know, our office has won that process. Our office has won each of these processes. You just want to know which process will be the best one for you. Process number 2 is file the I-360 first. The VAWA self-petition first is the VAWA I-360 petition. All right. And you're going to wait some time for that I-360 to be approved, right? It might take, it'll typically take at least a year for the I-360 to be approved. And then once that's approved and once your priority date is current, all right, you'll be able to file AOS. Now, sometimes in there, if you're in immigration court proceedings, you could move to terminate, all right, file the motion to terminate to the judge, get out of court, and then file the adjustment in front of USCIS. Or if you're in front of a stricter judge, or if you're in a jurisdiction where DHS won't join in, or if there's not willingness, if there's a complication in your case, for example, if the judge isn't willing to terminate your case, but you have an I-360 approved, you can file the AOS, the adjustment of status case, in court, and you can fight the adjustment of status in front of the judge. Got it? So VAWA in immigration court. Way number 1, motion to terminate first and file VAWA one step AOS in front of USCIS. All right. Method number 2, do the I-360 first. Once it's approved, then move to terminate. And if they won't terminate, then file AOS in court. Okay? So then what's step number 3, or what's method of applying for VAWA if you're in immigration court number 3? All right? We call it VAWA cancellation. It's cancellation of removal, but VAWA allows for a different type of, its own type of cancellation of removal. All right? And so it is different from the classic non-LPR cancellation of removal on Form E-42B. But VAWA cancellation is also done on the Form E-42B. All right? So what is VAWA cancellation, and how is it different from VAWA adjustment? All right? So VAWA cancellation, what is this? Yes, you've got to show that that you were either physically abused or subject to quote-unquote extreme cruelty, okay, by a U.S. citizen or a green card holding spouse, or in some instances, parent, okay. You've also got to show for VAWA cancellation that you were physically present in the United States for 3 years before the service of your notice to appear. So look at your notice to appear, look it over with a lawyer to make sure it was a legally valid notice to appear, all right? And see how much time you had in the U.S. You'll need to prove that you had that much time in the U.S. before the service of your NTA in order to be eligible for VAWA cancellation. You also need to show you have 3 years of quote-unquote good moral character, all right? No criminal record, talk over what good moral character means with your lawyer. We have lots of videos on that topic in our YouTube channel. Check that out. You've also got to demonstrate for VAWA cancellation that your deportation would cause extreme hardship. And it could be extreme hardship to you, yourself, right? Or your spouse or your children. Now, this standard, extreme hardship, is way better, way simpler to meet than the classic type of cancellation of removal, which requires a showing of exceptional and extremely unusual hardship. Like, that is a heightened standard versus extreme hardship is the VAWA cancellation of removal standard. So when a person's been victims of domestic violence by a U.S. citizen or a green card holder, they have a lesser standard of hardship that they would need to show. Got it? It's still not a simple level of hardship, but at least it's not that level of exceptional and extremely unusual that they require in other types of cases. Basically, you've got to show all of that, and you present it in court, and you fight it as a cancellation of removal case, and, submit if you are eligible for asylum. If there's any other argument as well, submit those also. And this type of case, you don't terminate this type of case, you fight it all the way. And so, it'll mean an individual hearing. It'll mean, we say individual hearing where we're talking about a trial in immigration court, all right? And you'll want to be ready to give your testimony in court. And then the judge will make a decision, all right? And if they decide to give you this, then you will win VAWA cancellation of removal, and it is a way of applying, and it does make a person eligible for a green card to be able to adjust status here in the United States, all right, for you and any minor children. So that's it, all right? And so when would a person use VAWA cancellation? Well, what if, for example, your I-360 for normal VAWA is denied by USCIS, right? If your I-360 petition for whatever reason is denied by USCIS, or maybe your adjustment through VAWA in front of USCIS is denied because they say you're inadmissible for some reason, well, hey, you might be still eligible to win VAWA in front of the judge through VAWA cancellation of removal. So there are times where when you can apply for multiple types of VAWA, and there's times when you try the first or second method first. If those get approved, great. You just won your ability to apply for a green card. But if they're denied for whatever reason, hey, you could fall back on what we might call Plan C, which is VAWA cancellation. So anyway, all of these are strategies. The conclusion of all of this is, if you were the victim of abuse, all right, and if you're now in immigration court, there are various strategies that you can try. And so you'll want to talk with your lawyer. You'll want to really think through the options that are available to you, all right? A good lawyer will explain to you, okay, if we do option A, it'll be this much time, you'll have this much probability of success, and it'll be they'll explain the costs involved and how much service is involved, right? Versus option B versus option C. Often and typically, if you're working with a lawyer, if you're working with a law firm, the more in-court representation, the higher the cost, all right? And so often the method A, where you terminate in court and then you do everything in front of USCIS, often you'll find it's a less expensive case, all right? Often you'll find that it doesn't require as much attorney time, as much like preparation and things like that, because the thing about VAWA cancellation or any type of case, when you're in front of the judge is either going to approve that case or order your deportation. And so when the stakes are that high, your lawyer is going to be with you every step of the way, and we got to prepare to make sure that it is as strong as possible to maximize your chances of success at that individual hearing. So that's it. Those are the 3 ways of applying for VAWA. What are they again? All right, this is pop quiz. See who's paying attention. All right, method number 1. First, you do a motion to terminate, so you're not in court anymore. And then you file VAWA 1 step in front of USCIS. That's beautiful. All right, if you can do that, if your judge or if DHS is willing to join that motion to terminate, great. We're seeing DHS do this a lot right now because it's the Biden administration. They were not doing this at all under the Trump administration. Okay? Option number 2, file the I-360 first, the VAWA petition first. Okay? Have your lawyer help you with that. And then once it's approved, then you can move to terminate. And if they're not willing to, fine, file AOS in court using that petition. All right? And finally, method 3 of applying for VAWA for people in immigration court is through what we call VAWA cancellation of removal. It's an E42B case, but with different regulations than the classic, quote-unquote, E42B cancellation of removal 10-year physical presence requirement. This is a 3-year VAWA cancellation, and it is very much a winnable case. All right, if you meet the requirements. So that really is it. I don't see that I've received any questions today. So if you have a question right now, now's the time. Send it over. And thanks to everybody who's here with me on YouTube, TikTok, Instagram, YouTube. Folks that are on Instagram, Lacey, I see you there. Hello. Brazen Lawyer. Hello, I see you there. Soledad Chavez. Hello, I see you there. Great to see you. Great to see each of you. Welcome. And so that is it, ladies and gentlemen. It is 10:33 in the morning. I really appreciate each of you being here. If you do still have a question that I haven't answered here, hey, please still send it in. All right. We always upload our answers to questions. We do that to our YouTube channel. We also often post them on TikTok and Instagram and other places. The best way to see those, though, is to subscribe to our channel in YouTube and to click the notifications bell, and then you can get additional legal updates and additional news. Anu, hello. Good to see you there on YouTube. Thank you. I think you're on YouTube. And it's hard for me to see sometimes where everybody's coming in from, but hello. Okay, Anu, thank you. You're asking, can I go live in India once VAWA is filed? If you're saying, okay, let me just clarify real quick. Anu, thank you for asking that question. If you file a VAWA self-petition, it doesn't matter where in the world you are, all right? But if you file VAWA self-petition and adjustment, the way immigration law works is once you've filed an I-485, adjustment of status, don't leave the U.S. Because if you filed an adjustment of status based on VAWA, then if you left, you would, quote unquote, abandon your adjustment process. So the best advice is to stay in the U.S. until either your travel document is approved. When you apply for VAWA AOS, you can apply for a travel document so that you could travel back to India, for example. Or just wait until your green card's approved, and then you won't have issue. Okay? I hope that was helpful. The other thing to know is that if you were to leave the U.S. with an I-360 pending, then you would probably need to consular process the I-360 and not AOS with the I-360. Talk to a lawyer, all right? That's my best advice, and we can guide you through the consular processing. It's annoying whenever possible. I would say file the AOS case and use. I mean, this is just maybe my own personal bias, right? When you file for VAWA, file for the green card. Do it all here in the United States, and it'll be a smoother process. Okay? All right, you guys. Thank you all so much. Anu, you're welcome. Thank you for asking that. Thank you for sending that in. I really appreciate it. Hey, thanks everybody for being here. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Welcome to our episode here of Deportation Defense Live. If you have an immigration case, please give us a call. We are here to help. If you have any other questions, please feel free to give us a call. Our consultations team is top-notch, and we are here to help, and we would love to do that. And so thanks. All right, thanks. So stay tuned for our Spanish episode. We'll do that in just a few minutes. And in the meantime, have a wonderful day, everybody. Thank you again, and we'll see you next time on our next episode of Deportation Defense Live. Thanks a lot. Take care. Bye-bye.